First question of the day is an interesting question because it's a person who filed bankruptcy with another attorney. Now again, I have no problem answering the generic question, but I'm not going to answer any specific. If you hired another attorney, I have no problem with that, but I'm not going to answer specific questions about your case. But this gentleman wanted to know about the 341 meeting. He asked his attorney, what are they going to ask me at the 341 meeting? And the attorney basically just said, well, they're going to ask you generic questions. That's not true. What they're going to ask you is specific questions about your case. You got to remember, when you file bankruptcy, you're putting all your personal information into this. You have to disclose everything. Now I'm talking everything, your income, your expenses, your assets, your debts, all got to be disclosed. Well, they're going to ask you at the creditors meeting to raise your right hand and take an oath that you swear you tell the truth, the whole truth, and nothing but the truth. And then you're going to have to say, what's your name? Is this true social security number? Are you who you say you are? Did you list all your assets? Yes. So now they've got you twice. Number one, I swore to it under penalty of perjury when I signed the documents. Number two, is this all true and correct again? Yes. And then they're going to walk you through. If you have a lot of assets, they're going to ask you about them. If you got a boat, if you got a car, if you got a Lamborghini, it's got to be there and it's going to be disclosed. Then they're going to ask you about your creditors. Have you listed all of your debts? And the answer's got to be yes. You can't hold back a Visa card and say, well, this one's current at the time I filed and I have a little balance and I want to pay it off. You can't do that. You've got to disclose each and every creditor. I don't care if you owe somebody $1. Uncle Bob, you borrowed $5 from him. You're going to list Uncle Bob in the $5. I don't care if you pay him back the $5 in a month. I don't care. But you got an obligation to list it because you are going to be asked, did you list all your creditors? And I don't want to put any of my clients in a position where they're going to have to commit perjury. It's not worth it, folks. You disclose the $5 to Uncle Bob. It's not that big of a deal. So what else are they going to ask you about? They're going to ask you about your income. They're going to ask you about your expenses. They may ask about your wife's income, even though your wife hasn't filed bankruptcy with you. In every case, if a husband and wife, well, obviously husband and wife are going to be married. If one of the spouses files bankruptcy, let's say my wife and I decide that I need to file bankruptcy, I have to disclose not only my income, but my wife's income as well. We got to look at total household income and the total household expenses. So if I'm going to have to claim her income, you better believe I'm going to claim her expenses, whatever they may be. So again, folks, everything's got to be disclosed. So really what the trustee is going to do is investigate the assets. They don't really care about the debts, I'll be honest with you. If you've got $200,000 in credit card debt, it is what it is. If you've got a mortgage on a property, it is what it is. They're looking at assets because you're only allowed to claim a certain amount of assets as exempt under Florida law. If you're using the federal exemptions, whole nother story. Excuse me. Whole nother story. So now what you're looking at is a situation where you're in front of the trustee and you're just answering questions about what your paperwork says, maybe clarifying things. So really, your questions are going to be about what your property is. So it's not that difficult. What I would suggest is if you're really uncomfortable and you're very concerned, get to the courthouse at least 30 minutes early. Hopefully yours is not the first one being called. The chances of that are pretty slim. But if it is, then you may want to go another day, a week before, and just see the questions that the trustee asks. At our office, we keep a list that we give each of our clients, the top 18 or 20 questions that the bankruptcy trustee may ask you. Then at the meeting of creditors, we try to go through it and see if there's going to be anything else. Let's say, for example, you own a boat. Well, the trustee is going to want to know, is there a lien on the boat? How old is the boat? How much do you think the boat's worth? How did you come up with that number? Did you get it appraised or did you just make it up? Is there a trailer? Is there a motor? Those types of questions. They're going to want to know about the asset because their job is to take the assets, which are not protected, turn them into cash, and give that cash to the creditors. Oh, and by the way, they get a piece of the action for doing that. That's how the trustee gets paid, which is always a big question in our office. People want to know that. So hopefully that answers the question. But yeah, there's no magic formula. There's no 10 questions that you're going to ask and then you're done. It's going to be individualized. But if you're a routine run-of-the-mill case, there's usually about 15 questions that the trustee is going to ask you, and then they may kind of deviate from that based upon your answers to the questions.